on the various bills that we'll be bringing to your attention today. Please type those into the comment box as we go. We will take questions as time permits. I do want to remind you that this is the third legal webinar we've hosted this year. The first one was on security devices. The second one was on commissions. Both of those are housed on the texasrealestate.com past events page where you can see the slides and audio. Upcoming webinars will cover surveillance in homes, floods or flooding on properties, and insurance. Be sure to look out for dates and times for those to be marketed, and we'll be hosting those throughout the balance of 2019. With that, we will go ahead and get started with how changes in the law affect your business. We have a panel of in-house experts who will be bringing you information today. I'm not going to go through this list right now, but I'll introduce everybody as we go, so you can attach a voice to a name. And with that, we're going to get started, and I will hand it over to our Director of Legislative Affairs and Chief Lobbyist, Daniel Gonzalez.
Thanks, Lori, very much. Good morning, everybody. Thank you for joining us for the webinar. We know when you're talking to us, or whether it's on a webinar or on the phone, you're not making money. So thank you for the hour you're going to give us. I promise this one slide is not going to take an hour. It's only going to take about 5 minutes. But we know we will be cognizant of your time. This session, thankfully, is over. It ended on May 27th, and as you can see from the slide, there were just over 7,800 bills that were filed, and of those, just north of 1,500 were passed, which represents a 19% sign rate or passage rate. That's really good, but it's also really low too. And I say it's low, and I don't mean it in a negative way. It's actually a good thing. Most bills that are filed are just horrible, to be honest with you. And that's what we do during the 140 days during a session, is we politely tell legislators how bad their bills really are. So thankfully, only 19% of bills ultimately do pass. This session really was interesting because we had a new speaker who was coming in, Speaker Dennis Bonnen. Our good friend Joe Strauss was retiring, and Dennis Bonnen was elected the new speaker. So a lot of folks didn't know exactly how the session was going to actually transpire with him working with not only Governor Abbott, but also Lieutenant Governor Dan Patrick. But thankfully, they did work well together. Really, the main focus for this session was about schools, about public education. And when you talk about schools, you're also talking about property tax reform and transparency. So really the two major bills, other than the budget, and really the budget is the only bill that has to be passed, and that's where they concentrated a lot of their effort. But outside of the budget, the two main topics for this session were property tax reform and school finance reform. And as I mentioned, they are tied together. Thankfully, finally, the legislature did come together on property tax reform, which is in Senate Bill 2. This was kind of a long time coming. Last session, they dealt with a similar bill on property tax reform and transparency. And really, this bill definitely represents the most dramatic changes to our property tax system since our system was created in 1979. And the main focus of Senate Bill 2 is really the rollback rate, and that is the rate that it used to sit at 8%, and now with this bill, it's going to go down to 3.5%. And that was a number that from one year to the next, a local entity could not raise more than 8% in revenue from one year to the next without having to go into a vote of the people, or go to the people to get a vote and approval of that tax rate. But that number now changes to 3.5%, which is more in line with what we are seeing with inflation and other matters there on the tax side. But that really is the main focus. It also gives more transparency, more information to property taxpayers. So no longer will local officials be able to say, well, we kept the same rate for the 7th year in a row, when in fact we know that by keeping the tax rate the same and your appraisal value is going up, that is a tax increase. So we're going to have more information available in taxpayers' hands, so they know exactly what's happening to them during the tax rate setting process. And they will know, they'll have a real-time tax notice where, as a tax rate is debated at the local level, and based on what their new appraisal value is for that year, that they will know what impact that proposed tax rate will have on their own property. That is something very new and that is going to be very, very helpful and impactful to taxpayers across Texas. The other bill, of course, that was coupled with it was School Finance Reform, House Bill 3. That includes about $11.5 billion more into the public education system, and about $5 billion of that $11 billion goes to property tax relief. There's some additional money that goes to buying down the recapture in these Robin Hood districts that have high property values, where they share their local tax revenue with other school districts around Texas. The state is cutting the recapture amount that comes into the state by 47%. So that's about $3 billion, and then there's the rest of the money goes into teacher pay and into the classroom. It's really, really going to be, I think, something that is transformative out there in the public education realm. I think hopefully we will see over the next 2 to 5 years the skills, the reading skills, the math skills of our students as they go through our K through 12 system, that we'll have a better outcome with this new influx of money in public education. So time will tell, but certainly I think a lot of people are giving House Bill 3 rave reviews right now. Other items that we were facing or that we dealt with, annexation. This was something that really stemmed from last session in 2017, where the legislature did pass a bill that gave protections to certain counties, to people in certain counties. And there were about 8 elections that occurred since that time in 2017. And your organization played a big part in these annexation elections to ensure that these protections on annexation were going to be applied to certain counties that did not have them. We won all of those elections by wide margins, and thankfully the legislature passed a bill this session that now takes those annexation protections and applies them to everyone in the state of Texas. So that was a huge win for us. And then finally, disaster recovery and prevention. Unfortunately, with the storm, with the Hurricane Harvey that came into the Houston southeast region of our state, there were a lot of things that ultimately we found that we could do better as a state in terms of our response. And there was, gosh, Kelly, I can't remember, 5, 6, 7, 8 bills that were ultimately passed dealing with disaster recovery. We'll talk about one of them specifically about the sellers goes a little bit later, but one of the main ones that was passed creates I guess, for lack of a better term, a disaster recovery account to help with future disasters. So that was created. And then finally, the TREC Sunset Bill, the Real Estate Commission Sunset Bill. This was something that we have been working on since last year in 2018, working with the Sunset Commission. The Sunset Commission, they review every state agency every 12 years, and they determine, they look at their structure, they look at everything that they do as a state agency. Well, this time it was the Real Estate Commission's turn to go under that review, and unfortunately for the Real Estate Commission, they did not get a raving review. The review was in our opinion very bad, and there were a lot of things that were uncovered at the Real Estate Commission that had to be ultimately addressed. Thankfully, the legislature did pass a sunset bill that extended the Real Estate Commission an additional 6 years. That's really significant because typically sunset bills extend state agencies by 12 years, but because of the scathing review that the Real Estate Commission received by the sunset staff and members during their review process in 2018, the recommendation was only to extend the Real Estate Commission by 6 years, not 12. So the legislature is going to keep their eye on the Real Estate Commission over the next 6 years to make sure that they're doing what they need to do, and hopefully become the premier state agency that we know that they are. But only time will tell with the Real Estate Commission. But like I said, the legislature as well as the Sunset Commission will be keeping their eye on the Real Estate Commission for the next 6 years. And Lori, Abby, and Kelly, and David, with that, I will complete my slide and answer any questions now that anyone may have.
I do not see any questions coming in, Daniel, but I'll interrupt myself and ask if any come in a moment. I will just add to the, and this is Lori, I will add to the TREC Sunset update that in the bill that passed, TREC is allowed to maintain its self-directed semi-independent status, but also they're required to do a lot of additional reporting to the legislature, the governor, and the Sunset Commission. So that goes along with what Daniel was saying about the review. Everybody wanted to keep a little bit closer tabs on the agency as we move forward. Specifically, the Sunset Bill also does some things that affect you as license holders that I wanted to bring to your attention. There is language that will become law on September 1st of this year that requires TREC to protect the identity of a complainant to the extent possible by excluding the complainant's identifying information from any notice that is sent to a respondent if you have filed a complaint with the commission. The bill removes the Texas residency requirement for all licenses regulated by TREC. That requirement is replaced with a requirement that license holders show they have geographic competency to operate in Texas. Also, the bill authorizes TREC to deny a license renewal in the event that the license holder is in violation of a TREC order. That is something that had not been spelled out previously in the statute. Additionally, the bill removes requirements for branch office licenses and any accompanying fee, which is another, all of these came out of the Sunset report and will take effect on September 1st. With that, we are going to move along to the other topics that we are going, before I move on to that, sorry, I almost forgot something. Along with Sunset, I wanted to mention the plumbers and the plumbing board. They were also under Sunset this session. Unlike the TREC bill, that bill failed to pass. It doesn't happen often, but it happened this session. I believe it happened with the dental licensing board like 20 years ago, and it was a really big deal. So for a while there, we thought that beginning September 1st, plumbers would no longer be licensed in Texas. This would not be good for consumers, property owners, people in Texas that use the services of plumbers who would have no way of knowing that they were educated and duly licensed. The governor did step in, though, a couple of weeks ago on June 13th and issued a proclamation. He used his executive order to continue the plumbing board and to continue the licensing of plumbers through, I think, May of 2021. That gives the legislature time in the next legislative session in 2021 to come back and either move that agency over to the Department of Licensing and Regulation or extend the plumbing board. The recommendation that had come out of Sunset that was in a bill that was filed would have actually abolished the plumbing board and moved those functions, keeping plumbers licensed, but through a different state agency. There were a lot of discussions about that, which ultimately led to the failure of the bill. So we will see what happens to them in 2 years, but for right now, plumbers remain licensed and nothing changes with respect to property owners being able to use a licensed plumber in the state of Texas. With that, we are going to cover, you can see on the screen what we're going to cover generally, and I'm going to hand it over to Abby Lee, who is our Senior Associate Counsel here at the Association for the first bills we're going to review.
Well, good morning, everyone. I'm going to talk to you about a handful of bills dealing with licensing, having to do with your license. Let's jump right in. The first two bills, House Bill 1342 and Senate Bill 1217, have to deal with criminal history, what a licensing authority can consider with regard to criminal history. So first off, House Bill 1342, this bill is effective September 1st. It limits the ability of a licensing authority like TREC to suspend or revoke a license, to disqualify a person from receiving a license, or deny a person the opportunity to take a licensing exam because of a criminal conviction that does not relate directly to the duties and responsibilities of that particular occupation. So currently, under the law until September 1st, that's something that a licensing authority can take into account if the person has been convicted of an offense that, again, does not directly relate to the duties and responsibilities, and that was committed less than 5 years before the date the person applies for a license. So this bill removes that ability. Additionally, this bill adds or modifies some of the considerations that a licensing authority has to take into account when deciding, based on criminal history, whether to revoke, suspend, or deny, like whether there's evidence of a person's compliance with any conditions of community supervision or parole. So that's House Bill 1342. Senate Bill 1217 has to do with prior arrest. What the bill says, and actually this bill is, this language is already in effect. It became effective June 14th. But what this bill says is that for the purpose of determining a person's fitness for a license, the licensing authority can't consider an arrest that did not result in a conviction or placement on deferred adjudication community supervision. And this is really in line with sort of a national trend that is discouraging the use of using prior arrests as a basis to make a determination, whether it's for employment or whether it's a decision based on housing, et cetera. So this is really in line with that. And in fact, the Supreme Court has weighed in on this and has recognized, quote unquote, that the mere fact that someone has been arrested has very little, if any, value in showing that he has engaged in misconduct. So really this bill is in line with that national trend. Switching gears here to Senate Bill 37, we have a bill related to student loan default. This is also actually already in effect. It became effective June 7th. So Senate Bill 37, it removes student loan default or breach of a student loan repayment or scholarship contract as grounds to deny a license or license renewal, or to take other disciplinary action against different types of license holders, including real estate license holders. And this really came from or was based on concerns that state laws barring professional license holders who are in default on student loans from renewing their license could be counterproductive, because doing so could inhibit a person's ability to actually repay the student loan debt. So that's sort of where that bill came from, and again, it is already in effect. Switching gears to Senate Bill 1200, this has to do with military spouses. And this bill arose or came out of a concern that when military families were relocating to Texas, that a military spouse was having issues or trouble re-entering the workforce. And so what this bill does, it's effective September 1st, is it says that upon notice to and then confirmation from the relevant Texas licensing authority, again, like TREC, it allows a military spouse to use an out-of-state license to engage in a business or occupation in Texas, as long as the spouse is in good standing in the other jurisdiction and the licensing requirements are substantially similar. Now, the military spouse can only engage in that particular business or that occupation for the period during which the spouse is stationed in Texas, but there is a cap on that, a time limit, which is 3 years. It can't exceed 3 years. So it's possible that in your business you might encounter someone who doesn't appear to have a Texas license, but in fact has been authorized by TREC to engage in real estate brokerage activity under this bill. And then rounding out the licensing category here, we have Senate Bill 1995. This is a little bit different in that its focus is on administrative rules or the administrative rulemaking process. But what this bill says is that effective September 1st, a state agency that issues a license, again, we could talk about TREC there, has to submit any proposed rule change affecting market competition to the governor's office for review and approval before the rule is adopted or implemented. And this comes from concerns about antitrust. So effective September 1st, the state agency, if there's a proposed rule that affects market competition, it's submitting it to the governor's office for review and approval.
Thank you, Addie. And before we move away from licensing, we did receive 2 questions about TREC sunset, which I'm going to go ahead and answer now before we move away from this issue. One question is, are we saying that a license holder does not have to reside in Texas? And that is correct. There's a general theme among the Sunset Commission staff in licensing generally. They try to remove barriers that they deem arbitrary if they do not impact consumer protection negatively. And this is one of those things that they deem to be a barrier to entry into the field. Because that was coming forward, TREC has already taken steps to require geographic competency I believe it's in a rule that has been proposed that will be adopted soon, and it's in the statute, so effective September 1st. Brokers will be responsible to ensure that their agents have geographic competency necessary to operate as a broker or agent in that area. Additionally, a second question that came in, do homeowners have the right to use a non-licensed plumber? If you will recall, in the Trust 1-4 residential contract and the other residential contracts, if the seller and buyer agree to repairs that the seller is going to have done, if a license is required in the state of Texas, the seller must use a licensed individual. That would have changed had the governor not stepped in, because the license would have no longer been required, and the seller could have anybody that's commercially engaged in plumbing activities do the work. But because a license is required, a seller would be required to use a licensed plumber if they agree to do any plumbing repairs under the TREC residential contract. With that, we are going to move over to general business operations, and I want to introduce David Jones, our Associate Counsel.
Thank you, Lori. Good morning, everybody. I will be discussing bills that affect just general business operations. So let's jump right in. First up is HB 3609. This deals with filing of assumed business names. This bill is effective September 1, 2019. First off, what is an assumed business name? We commonly refer to them as DBAs. And it is any name other than the name a business entity is actually formed under. If you're talking about an individual, it's any name that doesn't include a surname. The current rule, assumed business names must be filed with the Secretary of State and with a county clerk's office. What this bill does is it simplifies the process. So now the new rule, effective September 1, assumed business names only have to be filed with the Secretary of State. Next up, Senate Bill 1258. This relates to the prosecution of limited liability companies and other business entities under the Penal Code. This one also effective September 1, 2019. Now, this deals with criminal liability for business entities. This bill essentially just closed up a loophole. The current definition of business entities that can be found criminally liable, right now it only includes corporations and associations. So what about limited liability companies, general partnerships, all of the other types of business entities were not covered. So the new definition really just, it adds all these other types of business entities. So now the business entities that are covered are limited liability companies or other entity or organization governed by the Business Organizations Code. That's pretty much every type of business entity that Texas recognizes. So what is this criminal liability they're talking about? Well, if a criminal offense is performed by an agent acting on behalf of a corporation, association, or other business entity, and they are acting within the scope of the agent's employment, the corporation, association, or other business entity can be found criminally responsible for the offense of their agent. Now, agents include directors, officers, employees, or pretty much anyone who is authorized to act on behalf of the business entity. Now, obviously, you can't put a business entity in jail. So what the statute essentially does, it converts any criminal offense that calls for imprisonment, it converts that imprisonment to monetary fines for the business entity. So the individual can be found criminally liable, and the business entity itself can be found criminally liable and can be hit with a pretty substantial fine. Next up, Senate Bill 2342. This deals with court jurisdiction. This one does get kind of complicated, so I will keep it general today. It's effective September 1, 2020. So there is a little over a year before this one comes into effect. And this affects the jurisdiction and practices and procedures for civil cases before justice courts, county courts, statutory county courts, and district courts. What is jurisdiction? Jurisdiction pretty much just means what type of case you're involved in? Is it a family issue? Is it probate? Is it a breach of contract? And how much is actually at stake? Those factors will determine which court will hear that case. The one change that's most likely to apply to your business or possibly your client's situation is the change that was made to justice courts. Many people refer to them as small claims courts. Currently, it's limited to disputes over $10,000 or under. The change now increased that. It doubled it to $20,000 that a justice court can hear. So say earnest money disputes, breach of contract disputes, $20,000 or under can now be heard at the justice court level. Next up, House Bill 101. It relates to the creation. There's a new criminal offense in Texas. It's for false caller identification information display. This one also effective September 1, 2019. It creates a brand new crime. If a person with intent to defraud or cause harm makes a call using any type of technology that misrepresents their identity on someone else's device. So if someone makes a call and they're using some type of device that will change who they are or what number they're calling from, that is now a crime in Texas. Now, this doesn't apply to just blocked caller ID. So if you turn off caller ID and it just says, restricted call or unknown caller, that would not fall under this new statute. There are also exceptions for law enforcement and telecommunications service providers also have an exception.
Thank you so much for that, David. We're going to let you keep talking and move on to sales transaction issues. These are bills that are relating to your transactions. Okay, first up, bills that actually affect your transactions. We're going to discuss HB 1743 first. This is a good one for us. This deals with rollback taxes. Okay, the additional ad valorem tax and interest imposed as a result of a change of use for certain land. It is effective September 1, 2019. So we're talking about qualified open space land, such as agricultural use, wildlife management, and timber land. It gets appraised differently than non-agricultural use land. The way it gets appraised results in a much lower appraised value than, say, a typical market value appraisal. But if the use of the land changes, so it's no longer, say, agricultural use, the owner has to pay additional taxes, and those additional taxes are based on the difference the property would have been taxed if it was appraised at market value. And under the current rule, they go back 5 years from the date that it changes use. So it's not just when it changes going forward, they go back 5 years and they will tack on a 7% interest. The new rule, they are only going back 3 years, and the interest was lowered to 5% interest rate. So this is a good bill for owners out there, especially for a buyer who buys a property and then they're going to change it. Those rollback taxes aren't going to hit them as heavily.
And David, if I could say something, this is not only a good bill, this is a great bill. For the legislature to reduce the rollback taxes by 40%, it's never happened before. I mean, there have been bills that have been filed for the past 20 years, I think, to try to get this rollback tax period and the interest reduced. We actually supported this. We supported this bill and other bills, but the other ones that we were trying to really pass were the ones that were going to just completely repeal the rollback tax and the interest. But we couldn't get there. But a 40% reduction I think is going to be huge for not only for our members but their customers and clients, but I think just for generally the economy as a whole. So I think this one is going to be one bill to watch over the next several years on its impact on real estate.
David, before you move on, when does this bill take effect?
This is effective September 1 of this year.
Huge.
Okay, thank you, Daniel. Moving on, we have a pair of bills, House Bill 3815 and Senate Bill 339. These are what's known as companion bills. They're the exact same language, were filed in both houses. This deals with the seller's disclosure notice. This is probably the bill that's going to have the biggest impact on your day-to-day transactions. This one is a result of essentially Hurricane Harvey, and it requires much more detailed disclosures by the seller regarding flooding, essentially. Effective September 1, 2019, there are several new sections that deal specifically with flooding. New questions that a seller is going to have to answer on the seller's disclosure notice. One question deals with water damage not due to flooding. So say a water heater burst or something and there is water damage. That is now going to have to be answered by the seller. Present flood coverage, previous flooding due to failure or breach of a reservoir, previous water penetration into a structure on the property due to a natural flood event. Is the property wholly or partly in a 100-year floodplain, 500-year floodplain, floodway, flood pool, or reservoir? All of those are separate questions that a seller is going to have to answer. Good thing about this is that there are actually definitions provided that will be on the seller's disclosure to assist sellers in understanding what all of those terms mean. The 100-year, 500-year, floodway, flood pool, all of that's going to be defined for the sellers. A couple additional questions. Has seller ever filed a claim for flood damage? And has seller ever received assistance from FEMA or SBA, Small Business Administration, for flood damage? So those are the additional questions that you will see on the seller's disclosure. We are currently working on updating the Texas Realtors Form 1406, the seller's disclosure notice, our version of it. We anticipate that the new version will be available on our vendor sites on August 1st. So look for that. If you're using, say, zip forms, it should be on there August 1st. Now, you can start using the new version as soon as it is available. As I said, this bill is effective September 1, 2019. All the other rules regarding seller's disclosure notice, they pretty much remain the same. So the seller's disclosure notice, it applies to one unit, residential property only. And if the contract is executed on or after September 1, that's when the seller needs to start using the new version of the seller's disclosure notice. Now, a big question we always get whenever we change the seller's disclosure is, let's say you have a transaction, you got your listing agreement signed, the seller has already filled out the current seller's disclosure notice before the new version comes out. Okay, so now the new version comes out, and we always get, does the seller have to now fill out the new version of the seller's disclosure? Well, the key date is the September 1, and it is when the property goes under contract. So if the property goes under contract before September 1st, the seller does not have to fill out the new version of the seller's disclosure. But if the property sits on the market and you get to September 1 and there's still no contract, then yes, the seller would have to fill out the new version of the seller's disclosure notice. With that, Kelly, can you give us a little bit more background information on?
I think you have one more bill. 442?
Oh, I'm going to.
She's going to have a little background information on it.
Yeah, of course. Thank you, David. So I just wanted to share some background on these bills. They're particularly interesting. The initially filed versions would have required a separate disclosure form apart from the existing seller's disclosure form to ensure that the flood disclosures were made in situations where current disclosures are not required. This requirement would have complicated transactions and increased the risk that necessary disclosures might inadvertently been left out or not provided to a buyer. We strongly thought that the flood disclosures were a natural fit for the existing seller's disclosure form, a form that real estate licensees and their clients are already familiar with using, providing, and getting.
And ultimately, our government affairs team was able to win over the legislators by sharing a mock-up seller's disclosure form showing how the flood disclosures could be incorporated into and effective within our current seller's disclosure form. So these two bills in their final form adopted this approach such that you'll be able to continue to use a seller's disclosure form in the same way that you're familiar with, and buyers will be able to make more informed decisions based on the newly incorporated flood questions. So we think this was a win as well. Thank you, David.
And we did get a question on seller's disclosure notices. Does this affect property management, the leasing of properties?
Well, the seller's disclosure notice only applies to the selling of property, not to leasing. It is for a seller of one dwelling unit, so residential property of one dwelling unit, which would also cover condominiums. So no, it would not impact the leasing of property.
Thank you.
Okay, final bill for me is Senate Bill 442. This also deals with disclosures regarding flood coverage, but this is not for the sellers or even for agents. This is for the insurance company. Okay, this bill is effective September 1, and it would apply to policies, insurance policies, that are issued or renewed on or after January 1st, 2020. So it gives them to the first of the year to comply. This is for insurers that issue or renew commercial or residential property insurance policies that does not cover loss caused by flooding. They must include a statement, a disclosure statement in their policy documents. And I'll go ahead and read the actual statement. It's not that long. Quote, flood insurance. You may also need to consider the purchase of flood insurance. Your insurance policy does not include coverage for damage resulting from a flood, even if hurricane winds and rain cause the flood to occur. Without separate flood insurance coverage, you may have uncovered losses caused by a flood. Please discuss the need to purchase separate flood insurance coverage with your insurance agent or insurance company, or visit www.floodsmart.gov. So that is the disclosure statement that your clients, and you can probably see it in your own insurance docs. And again, it covers residential properties and commercial properties.
Thank you so much, David. With that, we're going to move back to Abby Lee to talk about leasing and property management bills.
All right. So there were several bills that passed that affect leasing and property management. So they may affect you or impact you as a leasing agent or a property manager, may affect landlords or your tenant clients. So we think you should know about these bills. So first off, let's start with House Bill 69. So this has to do with early termination as a result of a death of a tenant. Now, currently, under the law, before this particular bill goes into effect, just because a tenant dies, it doesn't mean the lease terminates automatically. The estate can remain liable. With House Bill 69, which is effective January 1st of 2020, for a tenant who is a sole occupant and that tenant dies, then a representative of that tenant's estate can terminate the lease and avoid liability for future rent and other sums if certain conditions are met. So for those of you that may be familiar with the early termination rights for a military service member or family violence, this is sort of similar to that concept. So what are the conditions? Well, the first condition is that the representative of the estate provides to the landlord or the landlord's agent a written notice of that termination. Second, the tenant's personal property is removed according to the procedure that's actually outlined in another section of the property code in Chapter 92, Section 92.014, which has to do with personal property and security deposits of deceased tenants. And then finally, if the landlord or the landlord agent requires this, the representative has to sign an inventory of the removed property. Now, the landlord, upon receiving the termination notice, and if requested in writing by that representative, has to provide a copy of the lease to that representative so that the representative knows what the tenant's obligations are. Termination, when is that effective? Well, termination is effective the later of the 30th day after the date the termination notice was provided, or the date on which all of the conditions have been met, those 3 conditions I just went through. So at the very least, we're talking about 30 days from notice to the actual termination date, but it could be longer depending on how long it takes for those conditions to be fulfilled. Now, importantly, the tenant's estate remains liable for any delinquent or unpaid rent, and also remains liable for damages to the leased premises not caused by normal wear and tear. And also importantly, a landlord or agent who lawfully permits a representative to enter the dwelling, to enter that property for the purposes that we just outlined, is not liable for any act or omission that happens as a result of allowing that entry. So again, that's House Bill 69, effective January 1st. Next, we have House Bill 1002. This is about as short a bill as you can get. House Bill 1002, it's effective also January 1st. It has to deal with terms of parking permits. Under this bill, a landlord who issues a parking permit to a tenant has to issue that permit for the same amount of time as the tenant's lease term, and can't terminate or suspend that permit until the date the tenant's right of possession ends. So I think this, according to the bill analysis for this, it stems from concerns that if there's a mismatched date, if the lease term varies from the parking permit term, that the tenant may face obstacles getting that renewed, and that may result in towing of the tenant's vehicles. So again, House Bill 1002, effective January 1st. Senate Bill 234, I mentioned earlier early termination for family violence. This bill is modifying that statute. Currently under Chapter 92, many of you know that of the Property Code, it allows a tenant to terminate the lease early in situations where the tenant is a victim of family violence, as long as the tenant complies with certain requirements. And one of those requirements includes providing a copy to the landlord of certain documentation. So effective September 1st, that list of the types of documentation that a tenant can provide is expanded. The new categories include a copy of an order of emergency protection, documentation from a licensed health or mental care services provider who examines the victim, or a victim's advocate. And victim's advocate is a specifically defined term in the Family Code. It also adds that these types of documentation would be sufficient in that co-tenant family violence situation where a tenant doesn't have to provide the 30-day written notice of termination. And really this came out of concerns that because of the nature of family violence, where the victim often lives with the offender, that there was a concern that victims needed a speedier and less cumbersome method be available to them. Senate Bill 1414, some of you may know this as the late fee bill. It is effective September 1st. And what does it do? Well, it amends the section in the Property Code, Chapter 92, regulating fees for the late payment of rent. I'm going to hit the high points here of the bill. First, the bill prohibits the collection of late fees until any portion of the rent has remained unpaid for 2 full days after the original due date instead of 1 day. So for those of you who use the example, you know, if rent is due on the 1st, you're not collecting or charging late fees until the 3rd. Now that's moved to the 4th. Second, there's a safe harbor now. So while the bill continues to require that any late fee be reasonable, the bill establishes a safe harbor where if late fees don't exceed a certain percentage, the fee is automatically considered reasonable under the law. So what are the specifics on that? Well, under the safe harbor, a rental dwelling located in a structure with no more than 4 dwelling units, a late fee can be considered reasonable if that fee is not more than 12% of the amount of rent for the rental period under the lease. So what's an example of that? So let's say the tenant's rent is $1,000, they're late paying rent. So to fall under that safe harbor, the total amount of late fees the landlord collects for that late rent payment should be no more than $120. So that's for 1 to 4. For a rental dwelling located in a structure that contains more than 4 dwelling units, a late fee is considered reasonable if the fee is not more than 10%. So if we're talking about apartments, we're looking at 10% of the amount of rent for the rental pay period under the lease. Now, importantly, even if a late fee exceeds those amounts, the fee can still be considered reasonable as long as the fee is not more than uncertain damages to the landlord related to the late payment of rent, including things like overhead associated with the collection of late payments. So this is essentially the same standard that's currently in the law. Finally, the other point I want to talk about this bill is the bill allows the tenant to request that the landlord provide a written statement of whether the tenant owes a late fee to the landlord, and if so, the amount of the late fee. So after that request, the landlord has to provide the statement to the tenant through an established means regularly used for written communication between the landlord and the tenant. However, important to note, a landlord's failure to respond doesn't ultimately impact or affect the tenant's liability for any late fee owed to the landlord. That's the language in the bill. So Kelly, as our legislative attorney, I know this bill has generated a lot of discussion and questions. So can you tell us a little bit more about the background of this bill?
Absolutely. So in recent years, there have been multiple lawsuits by tenants against multi-unit landlords, including a couple class action lawsuits last year, where the tenants alleged that the landlords charged late fees that were not reasonable, as required by Texas Property Code Section 92019. This litigation prompted requests for clarification in the law as to what late fee amounts are reasonable and therefore allowed. And Senate Bill 1414 provides guidance to landlords on how they can ensure compliance with the requirement that the late fee be reasonable and how they would otherwise demonstrate that the fee amount was appropriate. So I know a question that we get a lot, Kelly, is can the landlord charge more than 12% or 10%, whatever applies? So yes, this is not a cap. A landlord may charge beyond that amount, and doing so would put the landlord in the same position as current law. Particularly, the landlord would need to convince the court, if this landlord were sued, that the late fee was reasonable because the fee amount did not exceed uncertain damages to the landlord related to the late payment of rent. So essentially, it would be, for amounts above the safe harbor threshold, it would be status quo. You're going to have to demonstrate that the amounts charged were to cover the landlord's damages related to collection of late rent. So rather than being a cap, the safe harbor provides a way for a landlord to have assurance that they've complied with the requirement that the late fee be reasonable, as when you're under that threshold, it will simply be deemed reasonable. There won't be further consideration. A tenant won't be able to show under any circumstances that a late fee amount within the safe harbor is unreasonable.
And Kelly, this is Daniel. I guess one question, I've received the same questions that you guys have as well about whether this is a cap or not. But would you say that this bill, Senate Bill 1414, puts our landlords in a better position than where they are today?
Yes, absolutely. It's created a protection zone that if a landlord wants to take advantage of it, they can. Again, they can be assured if they do that the fee will not be deemed unreasonable. It will automatically be considered reasonable. Now, they do not have to do that. If they choose to exceed that amount, then they will be held to the same standard that exists today for all late fees, which is that you're going to have to demonstrate that the amount charged was tied to the uncertain damages that the landlord incurred related to this late rent.
And one thing that I would mention, Abby, too, is the reason why I did get this question early on before session ended, why the different numbers? And one of the reasons why you have 12% for single family 1 to 4 and 10 for others was because single family 1 to 4, based on what we were hearing from our members, completely different ball game than just multifamily apartments. So we even heard some staffers, even some members of the legislature, who would say, well, you know, realtors, all you guys have to do is just walk across the parking lot and drop 4 late notices to your tenants. And we have to politely correct them that that's not how most of our members deal with their rental units. They aren't apartments; they are single-family 1 to 4 units where they may have to go across the city. So it's not just merely walking across a parking lot like an apartment complex does. So we were able to get special consideration for 12%, which again, I think it was pointed out to us that no other state, I believe, Kelly, has a number that high for a safe harbor, quote unquote. So I really think this is going to be huge for our members. I think it's going to be a lot better, and I just want to make sure that people understand that this is not a cap. It's not capping late fees. That bill was defeated last session. That would have actually done that. This creates that safe harbor, and as Kelly mentioned, we believe it absolutely puts landlords in a better position today than they were yesterday.
Okay, thank you both. I'll just add one final thing. We've been getting some questions about this particular bill and other bills. Will there be any updates to the lease? Yes, we are updating the lease right now, and we'll have that for our forms vendors in time for your use upon the effective date of this bill. So be on the lookout for that.
Abby, I think this 1414 was September
1st, yes.
Because I know we're going back and forth on dates.
Some of the bills that I talked about are January 1st, but this one is September 1st. Final 2 bills I'll go through really quickly. House Bill 1152. This is a result of, or this bill was passed as a result of Hurricane Harvey, where there were concerns about price gouging. So this bill amended, effective September 1st, amends the Texas Deceptive Trade Practices Act and says it's a violation of the DTPA to sell or lease lodging, building materials, or construction tools at an excessive price or demand an excessive price for those. So think about that in respect to rental property. That limitation is during a designated disaster period, and that's defined in that bill. And then finally, we've got House Bill 4390 related to data breach. So under this bill, a person who has electronic sensitive personal information, I'll get to what that means in a second, has to disclose any data breach no later than 60 days after the breach. Currently under the law, it just says as quickly as possible. So this is putting an actual time period of 60 days in the statute. This part is new. The Attorney General has to also be notified no later than 60 days for the breach that involves at least 250 Texas residents. What does personal or sensitive personal information mean? Well, that means the first name plus the last name plus a social security number, a driver's license number, a financial account number, or information regarding a health condition. So why are we talking about this in the leasing and property management section? Well, often if you're going to have this information, it's going to be in this area because we've got a residential lease application that may ask for social security numbers or driver's license numbers. There may be a request for a reasonable accommodation come in from an applicant or a tenant based on a disability that might have health information. So something to be aware of if you host that electronically, or if your landlord hosts that electronically and there's a data breach, there's a 60-day time period for that.
And with the few minutes that we have left, I'm going to turn it over to Kelly Flanagan, our legislative attorney, to talk about guns on property.
Good morning, everyone. So several bills affecting guns on property passed this session. The 4 bills that I'm going to discuss all have an effective date of September 1st. House Bill 121. Currently, a criminal offense of trespass by person licensed to carry a handgun occurs if the license holder is orally told or notified in writing that entry on the property with a handgun is forbidden, but the license holder does so anyway without effective consent. So many of you see these written notifications in your daily activities, perhaps as you enter a coffee shop or your grocery store. When used, these signs state that entry on a property with a concealed handgun or openly carried handgun is prohibited. So what House Bill 121 does is add a defense to prosecution of this offense. Particularly, a license holder can avoid criminal liability if the license holder promptly leaves the property after personally being told by either the owner or an agent of the owner that guns are not permitted on the property. House Bill 302 prohibits a residential landlord from prohibiting tenants and their guests from lawfully possessing, carrying, transporting, or storing firearms or ammunition in the tenant's rental unit, in a vehicle located in the parking area for the tenants and their guests, or when entering or exiting the rental unit, vehicle, or leased premises. The bill enacts the same restrictions on landlords of manufactured homes regarding tenants and their guests, and on condominium regimes regarding condo owners, their tenants, or the guests of both groups. House Bill 302 then amends certain criminal offenses accordingly. Particularly, this bill allows a residential tenant, condo owner, or guest thereof to defend themselves against prosecution for trespass with a gun by showing that the person only carried the gun to or within their dwelling unit or on-site vehicle. These changes apply to leases entered into or renewed on or after September 1st. Senate Bill 741 states that a property owners association cannot include or enforce provisions in a dedicatory instrument that prohibit or restrict a person from lawfully possessing, transporting, or storing a firearm or ammunition, or from lawfully discharging a firearm if the person is otherwise authorized to do so. So, for instance, an HOA could not, through its restrictive covenants, rules, and regulations, or bylaws, prohibit a person licensed to carry a concealed handgun from doing so on their property. Lastly, Senate Bill 772 addresses situations where a person didn't prohibit the carrying of handguns on a property and a lawsuit is filed based on an injury sustained on the property. Particularly, the bill states the fact that a person didn't prohibit guns on the property cannot be used as evidence in a trial against a person who owns, controls, or manages the property, nor can this fact be used to support the injury-related claims in such a lawsuit. This protection from liability applies to business entities as well as individuals. For instance, in a case where a person was shot on property being managed by a property management company, the fact that there wasn't a sign posted on the property prohibiting guns couldn't be used against the property owner or the property management company at trial. And that concludes my bills.
Thank you, Kelly. As a reminder, we did record today's session. You're going to receive an email from us later today. It will include the audio, and it's going to be posted on texasrealestate.com under webinars, under past events, along with the slides. We did receive numerous questions today. We tried to answer a few of them. We're just not going to have time to go into all of them, but most of the questions are relating to the late fee bill and seller's disclosure notice. Please note that one of our upcoming legal series webinars will deal with flooding, and we'll get into that in more detail, and I think we can include more information on seller's disclosure issues with respect to flooding there, and I expect that we will be putting out some written information, whether through our blog post or in the magazine, both on late fees and on seller's disclosure notice. Generally, a lot of the questions we got weren't related to the bills, but were general legal questions about what the law requires. Please don't forget that you can always call the Texas Realtors Legal Hotline. Just don't all call at once. You will make our hold times go way too long, but please always use that resource for general information about the laws and the statutes in the state of Texas. With that, thank you very much for your participation today, and we look forward to seeing you on another webinar in the future. Thank you.